Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Well, good morning.
SJC-12632, Wayne Chapman v. Commonwealth of Massachusetts, and SJC-12537 in the matter of Wayne Chapman.
So, Ms. Murray, I guess we begin and end with you.
Good morning, and may it please the court. Johnstone is wrongly decided. It is plainly wrong, and it does not further, but rather it frustrates the salutary purposes of the statute. This court should overrule it because, as this case shows, it creates unintended and dangerous consequences that threaten public safety by according both an adjudicative function and an assessment role and a fact-finding role to people who are witnesses. As the statute says in Section 9 and Section 13A, qualified examiners are to conduct examinations, provide their diagnoses, and submit reports with their recommendations for the outcome and the disposition of the petition. In no sense are they intended to be the fact finder. In no sense are they intended to have an adjudicative role. And giving it this dispositive weight is plainly at odds with the role of other experts.
So what could we possibly have been thinking then?
Well, I don't know, but it is clearly an error. And I would draw the court's attention to the prior versions of the statute where the reports did serve of the qualified examiners and qualifying psychiatrists going back to 1958, where the report in an initial commitment case, never in Section 9, but in an initial commitment case, in order for the petition to proceed to commit somebody, the reports of the evaluating psychiatrists and then qualified examiners, when that term was added in 1985, had to clearly indicate that the person was sexually dangerous. That language, as the appeals court pointed out in Hosey, which is cited in the Commonwealth's brief on page 48, its opening brief, the appeals court said that language is no longer contained in the statute. So those reports had to clearly indicate. But even then, as this court talked about in Klein and as the appeals court talked about in Hosey, those reports weren't entitled to dispositive weight if, for example, they contained an error of law. And both in Klein and in Hosey, the qualified examiner in the case, two different examiners in the cases, had misconstrued the statutory requirements. And as the court said in Hosey, that was entitled to no weight, very little, if any, weight, when the person who's conducting the evaluation is mistaken, as we all are from time to time.
Okay, can you identify any case in which this court, after unanimous decision interpreting a statute, has reversed it and said that the interpretation of the statute was wrong? Isn't it generally that when we interpret a statute, if the legislature thinks we're wrong, they revise the statute?
Well, there are a couple of questions there, and I'd like to address them both, Chief Justice Gantz. First, I would point to the Ruiz case, where this court reversed Pelletier in a unanimous opinion, which was an 11-year-old decision at the time that the court reversed it in October of 2018. And secondly, with respect to the legislature's inaction, the legislature absolutely should act here. But such action would not affect this case and would not protect the integrity of the court or public safety in this case and the other cases that are currently pending, which have this very issue in them, I should say. Further, we should not consider legislative inaction of a subsequent legislature to be any indication of the intention of the legislature that enacted the measure in the first place, as this court said in the MCAD versus Liberty Mutual case from 1972. The action of a subsequent legislature. Still further, We can't speculate on what kaleidoscope or collection of events have caused inaction by the legislature. As I said, they absolutely should act.
Okay, let's imagine a world in which we do what you say we should do, and we reverse Johnstone. Let's see how that would play out in terms of determining whether or not the legislature intended the result which the Johnstone court said the legislature intended. So let's take a Section 12, an initial commitment hearing. Commonwealth decides that it wishes to proceed. There's a probable cause hearing. Person is held. Statute then says the defendant can be held for 60 days, and the report to the qualified examiner is due within 45 days. Correct?
That's right.
And then the legislation provides that the DA is not permitted to even decide whether to petition for trial until 15 days after it receives the QE reports. Correct?
Right.
So what do you understand the legislature to have intended when it rested the decision of the DA whether to proceed on its receipt and one would think consideration of the QE report?
That's right. And there's nothing inconsistent by saying consideration is not disposition. So, of course, those reports are filed with the court. That is information for the district attorney, who has the option of proceeding to trial with its own retained expert, which this court required in Bruno that it obtain for probable cause to meet the probable cause standard. There is nothing inconsistent about that. It gives information to the district attorney, who has the option of proceeding or not. And I would point out to this court that Mr. Johnstone's initial commitment was affirmed without a qualified examiner opinion. Both qualified examiners said no. His initial commitment was affirmed in an unpublished disposition by the appeals court, and further review was denied by this court. So that has information. But the district attorney has an expert for which probable cause has been found, which means that there is at least sufficient, given the probable cause standard, data to go forward. Now, if that expert were to withdraw his or her opinion, then of course the district attorney would not have expert opinion anymore, which was the situation in one of the two companion cases in Doobie.
Now, the legislature doesn't provide for any revisiting of the probable cause decision if the both qualified examiners were to find the person not sexually dangerous, and indeed requires that that person be held for trial, which, as you know, may take a year or two. So the consequence of what you're providing would mean that an individual could be held for a year or two awaiting trial, even after both QEs have found him not sexually dangerous.
That's right, because the probable cause expert opinion is sufficient to warrant that detention. And the management of the trial, first of all, the statute requires a trial within 60 days. If the case does not go...
But you know full well that that almost never happens.
It almost never happens, but quite frequently, because there are requests by one or both sides that a judge rules on, finding good cause. Oftentimes, the offender's attorneys want more time to get experts. They want to have subsequent evaluations done. Sometimes they want their client to go into some of the treatment available to temporary detainees so that the person is in treatment at the time of trial. But that, in the first instance, the timing of the trial is in the control of the Superior Court. And as we see from some of the many cases that have looked at the timing of the trial, DeBella, Lynch, those cases, the court, a reviewing court, can then look at whether those delays were justified. So in the first instance, that is entrusted to the Superior Court to decide, as Superior Court judges are called on every day to decide whether to grant a requested continuance and if it's meritorious. And quite often, as we see in these cases, it's either by joint agreement or by request of the offender who wants the additional time. So that in and of itself is not cause to allow the QEs to have the dispositive outcome without opportunity for testing, as expert opinion is tested all the time in the crucible of cross-examination and direct examination at trial.
Along those lines, let's just say for the sake of argument that because of that concern, we actually have in our jury instruction, experts don't decide cases, juries do. And so let's say that there's a serious concern that Johnstone is wrong. You know that's not enough or even close to enough for us to reverse it.
This court has the power to reverse a prior decision when it is wrong.
I understand that, but it's a statute. It was interpreted by this court. It's a statute that was interpreted by this court, and now we're revisiting that statute. We're going to say, and we have to say, well, that statutory interpretation was wrong in the face, as the Chief just pointed out, the legislature having an opportunity and actually having amended that particular statute previously. I'm just trying to make the point. You can't just sit there and say to us, Johnstone is wrong, Johnstone is wrong, Johnstone is wrong, plus. Plus what?
Plus, the court could not have known then the consequences that would
That's
result.
up to, this is not a public policy discussion. The consequences are for the legislature to decide. It's not a public policy discussion. Johnstone plus what?
First, Justice Lowy, this court should not wait for the legislature to correct its own error and restore the powers of the court to act in these cases, to ensure both proper application of the law and justice in any particular case.
Would you address the due process overlay? Because we have an extraordinary statute that allows for the deprivation of someone's liberty to protect public safety. And you certainly acknowledge that in order to do so, in order to have this statutory scheme, it needs to be fully in accordance with due process rights. And the trouble I have with some of your analysis is concerning trial rights in a regular criminal case. This is not a regular criminal case. There's a huge due process overlay that makes this statute constitutional. So would you address that for me, please?
Certainly. Due process, as this court said in Bruno, requires proof of a mental condition that makes the person likely to reoffend sexually if not confined to a secure facility. Bruno then went on to say, the court said in Bruno, that the Commonwealth is required to produce expert opinion. But it did not say that that expert opinion has to come from any one particular source. So due process requires expert evidence, and the Commonwealth does not quibble with that. But there is no due process right to an evaluation by an evaluator that's created by statute that the statute could at any time do away with. The requirement is the Commonwealth come forward with expert opinion and all the other evidence to satisfy the elements of sexual dangerousness, including proof of prior sexual misconduct, and proof that the person is likely to reoffend by reason of this mental condition. And that is what is that's when due process is satisfied. And long before Johnstone, this court said that both the pre-1990 version of the statute in Dutiel and the 1999 statutory amendments that were considered in Bruno comport with due process. Expert opinion is required, absolutely. But when the Commonwealth is prepared to go forward with experts from another source other than the statutorily designated qualified examiners, then the case should go forward and be resolved by a trier of fact.
Now, counsel, in 2016 in Ray Green, we revisited Johnstone again to some extent. Can you address the court's reasoning in that case?
In Green, which Johnstone did not provide an opportunity to invite the court to revisit or overrule Johnstone because that was a case with split qualified examiner opinions, the court considered Johnstone and said that there was a requirement that the jury must be told that they have to credit the opinion in some fashion of at least one of the qualified examiners, which the Commonwealth argued then and maintains to this day was encroaching on the jury's responsibility of weighing and assessing evidence. And Johnstone flies, frankly, in the face of many court decisions from this court. It is an outlier. It flies in the face of many of those decisions which say, we don't say who to credit. And the jury or the fact finder, if it's a trial judge, decides. And the court has pointed out in Cowan and in Blake, in Hosey, which I mentioned earlier, where fact finders have assessed opinions from qualified examiners, and in McIntyre. and found them lacking and didn't credit them in some respect.
Can you tell us, before your time's up, can you tell us, please, how does our interpretation of the sexually dangerous person statute comport with other courts and other jurisdictions and their own statutes?
The requirement of expert opinion is consistent, but a number of other statutes have, from other states, have different statutory structures about, in the federal court, the federal statute as well, have different structures about the source of the expert opinion. Some have court-appointed experts, some have each party retaining their own expert, the government and the offender. So it's the requirement of a mental condition is certainly the case, as the Supreme Court said in Hendricks and in Crane, and that is still here. What the Commonwealth is asking for is for the court to overrule Johnstone to the extent it prevents the Commonwealth from going forward when it has expert opinion from a qualified expert to go forward.
And when you say it has expert opinion, who is that from exactly?
Well, it can come from a number of sources.
In this case?
In this case, it would come from one or more of the 3 expert members of the Community Access Board.
Weren't they reporting, though, on their report? I mean, that has input from lay people, correct?
It has some input from treatment providers. It had input from Mr. Chapman's medical providers. It had input from his, obviously, and it's well listed in the record, what they considered all of his criminal records, his entire history of treatment, back when from the time he was committed in the late 70s through 1992 at the treatment center, and from the time he was back from 2007 till 2000 and to the present.
Is there a qualified examiner on that board?
All 5 members of that board are designated as qualified examiners in this case. And of course, should there be a question about the expertise of any expert that any party is bringing forward in a case, the Commonwealth or the offender, then of course, in the first instance, the trial judge has the opportunity of assessing the credentials before the case goes to trial. But in this case, each of the witnesses the Commonwealth would seek to call have all given expert opinion as in the courts on the subject of sexual dangerousness, and they've all been designated as qualified examiners. And it is utterly illogical to suggest that you're only an expert when you wear the qualified examiner hat, and you're not an expert, or you're no longer an expert worth considering when you're wearing a different hat, whether you're retained by the district attorney or whether you are sitting as a member of the Community Access Board, appointed by the same person who appoints the qualified examiners. So for all of these reasons, the Commonwealth asked the court to revisit and overrule Johnstone to the extent it prevents the Commonwealth from going forward when it has expert opinion, as well as evidence sufficient to meet the criteria of proving beyond a reasonable doubt that Mr. Chapman is today sexually dangerous. And unless there are any other further questions, the Commonwealth will rest on its brief.
All right, thank you. Mr. Tennant.
Morning, Your Honors. Eric Tennant on behalf of Mr. Chapman. Johnstone correctly interpreted Chapter 123A to mandate that when 2 qualified examiners say that someone is not sexually dangerous, that person must be discharged. And in the 10 years since Johnstone, nothing has changed factually that would warrant overturning it, and more importantly, the legislature has not sought to change the law, even though they have amended portions of 123A since then. And even though they have been presented with legislation to change this, they have not addressed it. At its most basic, this is a case about the dialogue between the court and the legislature when it comes to interpreting statutes. There's a great quote from a recent U.S. Supreme Court case, Kimball, which is cited in our brief. The case is. But the quote is that stare decisis carries enhanced force when a decision interprets a statute. Then, unlike a constitutional case, critics of our ruling can take their objections across the street, and Congress can correct any mistakes it sees. And that really is what this is about. This court interpreted a statute based on its understanding of what the legislature intended, the kind of scheme the legislature intended to create so that that scheme would be constitutional, so that that scheme would protect the rights of the individuals who are being committed. And then the legislature, if it believed this court was erroneous, could have and still can amend the statute. Even after today's decision, if this court were to uphold Johnstone, the legislature still has the power to do that. And that is the biggest reason why you should not overrule your own decision, simply because there is new judges on this court that perhaps may disagree, I don't know, but that is not enough to overrule it. Even if you're thinking about it, so first of all, nothing factually has changed. In the 10 years that Johnstone was decided, cases have been proceeding pursuant to how this court said the statute should have them proceed, and when 2 qualified examiners opine that someone's not dangerous, that person is discharged. And the Commonwealth has not pointed to any problem in that process that would warrant overturning it. The Commonwealth keeps saying that there are some serious public safety issues, and yet they can point to none other than they don't want Wayne Chapman released. And it wasn't until his came up that they, for the first time in 10 years, decided to appeal this and say there was a problem with Johnstone. Up until that point, there wasn't a problem with Johnstone.
And we have legislation pending now, is that correct?
There is legislation that would
pending
address...
and how would that make, what kind of change would that make in the statute?
So I think the most basic change would be that, my understanding of having read the proposed legislation, is that if there were other doctors other than the qualified examiners, so presumably from the Community Access Board, those doctors could also, that would be enough for the Commonwealth to go to trial. The legislation changes the Community Access Board a little bit, so it's not quite using the same terminology, but I think that's the best way to understand it. It sort of expands the universe of doctors that are available for a trial. So I think that's the biggest change. And that was proposed weeks, months, I don't know, after the QE reports came out in this case. So that is there. And if the legislature believes that's the way to go to change this, they can do that. And if there are constitutional problems with that, we can deal with that. But that is up to the legislature. I want to address some of the points that the Commonwealth makes. The Commonwealth makes points, for example, that sometimes on the Community Access Board there are persons who are also qualified examiners. And that's true. There is an overlap in the doctors, and sometimes they work as qualified examiners, and some of them are on the Community Access Board. And in this case, that's true also that there were qualified examiners on the Community Access Board. The problem is the Community Access Board is not intended to provide the same function as a qualified examiner. And so even though there may be someone who is a qualified examiner sitting on the Community Access Board, in theory, they are not providing the same kind of evaluation.
Well, I assume the Commonwealth says that apart from the Community Access Board, if they were to hire a private psychiatrist or psychologist, they could render the same opinion as a QE, and that would be enough to go forward. So you don't have to go to the cab. Right?
I do think that is one of the logical outgrowths of their decision.
Right? They could shop for an expert, and that expert would be sufficient to go forward.
I think that has to be one of the interpretations of what they could do, and I think that's problematic. It's problematic because it's clear that the legislature intended the qualified examiners to be the persons, the experts who control discharge. And I think one of the ways to think about it is because they are also part of the initial commitment scheme. So that is, the legislature created the qualified examiners both as a gatekeeper for initial commitment and for discharge. There's no Community Access Board in initial commitment. And in fact, a probable cause doctor wasn't even something that that's in the statute. The idea of having an expert who's not a qualified examiner at the initial commitments came about because this court correctly said that you have to have some sort of expert testimony that's constitutionally mandated to even hold someone temporarily while they're being evaluated by qualified examiners. So that was where a lot of doctors from probable cause came from. But if you take a step back, you can tell that the legislature intended the qualified examiners and the qualified examiners only at the initial commitment stage to be the doctors who control that. And if they were to say the person's not dangerous, then the person should be discharged. And so logically, that should follow through to the discharge proceeding. And so if the Commonwealth is all of a sudden allowed to hire experts, there is no stopping point to that. And it can't be that the legislature intended for these trials to basically allow dozens and dozens of experts until they get to someone who says someone is not dangerous. That was the point of creating qualified examiners. The other reason that qualified examiners are important for constitutional reasons is because, as this court well knows, the reason civil commitment is constitutional, one of the reasons is because it allows for detention only so long as someone is deemed dangerous. And the minute that someone is deemed not dangerous, they are no longer allowed to be held. Otherwise, it would be unconstitutional. So what do qualified examiners do? Qualified examiners are
Does that address the point in time from the QE report up until the time of trial for 2 years? Right, so if the QE now becomes advisory and the government is able to hire an expert, there's a natural delay, and there's going to be a delay. There is a delay, and there's going to be a delay from that time until time of trial. So are you addressing that constitutional deprivation at that point in time between those 2 points?
I think that's part of my point, which is the legislature designed a scheme that said, we want to have experts evaluate these persons, but we recognize that someone can only be held so long as they're deemed dangerous. And so we are going to measure that with these 2 qualified examiners. And so when these 2 qualified examiners, if 2 qualified examiners say someone is not dangerous, that is enough for us to say that person should be released and not expand the process beyond the point that might make it unconstitutional.
Because the answer to your argument, I suppose, would be, well, someone is going to decide if they're dangerous. That would be a judge or a jury. But what you're saying is it's more than that, because it deals with the deprivation of liberty between QE report and trial.
Well, yes, it's both of those, because first of all, if 2 qualified examiners say someone is not dangerous, there is no trial. There's nothing to do at trial. At that point, it's just procedural to get to the point of discharge or release.
Does anyone review the report?
I'm sorry?
I'm sorry, does anyone review the report that they make to the court?
The qualified examiner reports?
Yeah. Suppose they're wrong. Suppose they're on their face wrong.
So it depends on what you mean by wrong, because theirs is ultimately an opinion. And if their opinion is that someone is not dangerous, that is their opinion. And it's not for a judge.
Suppose it's based on facts that are not really accurate, and the judge knows that.
And the judge knows that?
And the judge knows that.
So I don't know how the judge would know that and how the judge would
Record
make
evidence, suppose they've just screwed it up.
I don't know. So, okay. So one answer is, I suppose that's why they picked 2 qualified examiners to assure that there's not just a mistake that goes through, so that...
Do the 2 qualified examiners confer with each other?
My understanding is they don't. My understanding is they provide independent assessments.
Okay.
So they do their own assessment. They meet with the person, review records. They write a report. That report is not reviewed by either side. That report goes through the entity that provides the qualified examiners. And then once those reports are finalized, they are sent to the court.
And why are they sent to the court?
Because that is the way the statute envisions it, that the statute says
What is the role envisioned for the court at that point?
At that point, at that point is for the court to review the report and get to the last sentence. And if the sentence is, our opinions is that the person is not sexually dangerous, then the court says, okay, the qualified examiners have performed their function under the statute and the person is entitled to discharge.
Gatekeeper.
Yes. One of the reasons a judge doesn't need to go in further is because there are safety measures built into this. So for example, the legislature built in a certain experience that someone has to do this. So you can't just be straight out of having finished your dissertation and never having worked on one of these cases before and be a qualified examiner. It's people who have a certain amount of experience who do this. You have 2, so that you make sure there's not a mistake. It would be unlikely that both doctors would be making some mistake that would be so erroneous that would result in them believing someone is not dangerous if they think the person really is. There are safety measures built into that. That's why you have that. But the court, by statute, has no role in that once the reports are final and once those decisions are final based on those individual assessments. The legislature could do differently if they want to, again, but this is the scheme they decide to work with all the problems that it comes with civilly committing some of the constitutional issues that you have, and then just the efficiency of getting through this process.
Now, the legislature has directed that the person be held until trial after a probable cause hearing under Section 12, and under Section 9 be held awaiting that trial. And I guess the consequence of the Commonwealth's position would be that that person could be held for trial based on probable cause alone.
I apologize. I'm not sure if I understand the question, but I think if what you're asking is, yes, someone can be held after probable cause, but the point of that is because that is the point of time in which they're being evaluated by qualified examiners.
Right. The statute provides the Your argument, I gather, is that it's probable cause gets you to the 60 days.
Correct.
And then if both QEs decide the person is not sexually dangerous,
Right.
then that terminates the justification to hold somebody.
Correct.
If you could turn to the statute that governs dangerousness in general, persons dangerous to themselves or others, not necessarily because they're sexually dangerous. Can you compare how the legislature has handled that in terms of the standards versus the standard here with regard to those who are dangerous for reasons of sexual dangerousness?
To be perfectly honest, I do not normally do that work, and that's not something that I research. I'm not entirely familiar with that process, so I don't know. I imagine that the 123A, the sexually dangerous person, is vastly different because there are different consequences and different findings that have to be made. I don't know how one compares to the other. I don't believe there's any such thing as a qualified examiner, for example, in the just the mental health civil commitment. I don't believe there's anything where someone has to have 2 years or a certain type of expertise to even conduct that, to be appointed by someone within the executive, things like that. I know the timelines are different. I do know that, and the reviews are different and stuff like that too. But beyond that, I apologize. I just don't know enough about that scheme. To be perfectly honest, unless this court has any other questions, I would rest on my brief.
Well, before you go,
Yes.
so if we do change it, what else must we change? Obviously, Green would have to be, we'd be reversing Green too.
Sure, Green would no longer make sense, really, because I don't think Green would make sense if you were allowing other doctors to form the basis for a finding. So Green instruction would no longer be valid.
What would be the effect in terms of the time period to get individuals tried under Section 9?
I think, to be candid, I think it would be more, the initial commitment process would be more affected than the Section 9 process. The Section 9 process, if all that is happening is that you are allowing Community Access Board members for their opinion to allow the Commonwealth to go to trial, that process is fairly set, and those decisions tend to come out around the same time. So I don't think that would delay things. The initial commitment process, I think it could change things if the Commonwealth is now seeking independent experts or seeking other sources of expertise that they might not have ready when the qualified examiner decisions are ready at the initial commitment process, because in theory, someone is entitled to a trial 2 months, 60 days, I believe, after the QE decisions come in the initial commitment. And the Commonwealth now is saying, well, wait a minute, we want to look for other sources of expertise. I doubt that that would be able to wrap up in such a quick time. So I think initially you would have delays, you would have persons being held beyond the time they should be, even though you have 2 qualified examiners saying the person is not dangerous.
All right, thank you.
Thank you very much.
Ms. Murphy. Good morning.
Good morning. May it please the court. I'm Wendy Murphy here on behalf of the appellants who were petitioners below in the 211-3 case. Before I address some of the substantive questions, I'd like to say that were I not a party here, I would have filed an amicus brief pursuant to the court's solicitation of amicus briefs. So to the extent you find that we have no standing, I'd just like to request that you accept the briefs that I have filed on the merits of Johnstone as an amicus brief. I know that's a little unusual as a request, and if necessary, I can file it after argument as a brief itself, but I would like to be heard and to make sure the record reflects that the third-party interests of victims and the public interest generally ought to be reflected in the record, that there is a strong view of the fact that Johnstone ought to be at least amended, if not overturned. And we've made those arguments. However, if you rule that I have no standing, those arguments won't be heard, and I think they ought to be heard. As to the question of standing, I think that the court, the DOC, and Mr. Chapman have completely misunderstood the point of our standing claim. The basis of our standing claim is not 258B. If it were, I would likely, at least in part, concede the question. We did not seek standing under 258B, the so-called Victims' Bill of Rights law. We sought standing under the regulation 803 CMR 902, which is broader. And frankly, it has nothing to do with 258B. It is a regulation promulgated under Chapter 6, Section 172, sub K, which allows the notification registry to include not only victims of the underlying offense, but also persons accepted as eligible by the DOC, which can include, and in this case does include, three of the four clients I represent, are not victims of Chapman's underlying offense. They are part of and listed on the registry under this broader provision of the regulation that allows people to be listed if they are considered eligible, and eligible under 172K means that you've expressed to the DOC your concern, your fear, if you will, upon the release of a particular identified offender.
So where does this go? So let's assume we have a situation in which the DA, having reviewed the QE reports, decides not to proceed. Is it your view that the victims can proceed to attempt to find the person sexually dangerous even though the DA has decided not to proceed?
Oh, not at all. No, no, no. The only reason we addressed some of the issues in Johnstone was because Johnstone is responsible for why the victims and the other members, the other appellants, didn't receive adequate notice. So I think we had the right to at least point out to the court the way that Johnstone essentially repealed the 14-day notification requirement. And I have no doubt this court did not know that it was doing that with that case.
Say it repealed it, but if an individual does proceed to trial and is found not sexually dangerous, you don't get 14 days advance warning of the jury's verdict.
That's not actually how it works in practice. They are notified that there is a trial coming, and they are often present. My clients have been present in the room during the trial process, so they do have 14 days advance notice. That has happened consistently in this case. This is the only time they did not receive 14 days notice, and it's because of Johnstone. So our argument about...
So your view is that if somebody is deemed not sexually dangerous, whether it be as a matter of law or because the DOC or DA decides not to proceed with the case, that person should be held for 14 days to give the victims notice?
They've always received adequate notice because they've been apprised in advance that there is a hearing or a trial coming up. This is the only circumstance under which they're not able to get that 14-day notice.
So you're not saying, are you, that no other case, there's been no other cases where qualified examiners have found somebody, both of them, not sexually dangerous, and therefore the Commonwealth didn't proceed? This can't be the only case.
Oh, I'm sure it's not. It was the only one I'm aware of.
So in those cases, did those victims get notice?
I'm not aware.
So we can't say this is the only one then.
No, this is the only time these individuals,
these people,
in
right.
the Chapman case in particular, failed to get 14 days advance notice.
The other section of the Code of Mass Regs, not you quoted 803 Section 9, but Section 9.092 also provides for the no less than 14 days, but there's also provision in Section 4. They anticipate that there may be times when that can't happen.
Correct.
So that's anticipated.
Well, no, Section 4 is very precise about those types of circumstances. There's no catch-all in Section 4 that says, or any time the department sees this as an emergency or can't reasonably notify. They're all very precise. And this court and the DOC and Mr. Chapman have all said that the exception that applies here is the so-called court-ordered release exception. There was no court order here, and that's exactly the problem. That's the problem with Johnstone, that it doesn't involve any court involvement. It doesn't require any court involvement. Had there been a requirement, and maybe that's how you correct Johnstone, you just simply require that the court look at the two QE reports, even when they both agree about non-dangerousness, and the court could take those 14 days to both respect the 14-day notification requirement and review the QE reports to see whether, for example, they contain errors, as Justice Lang asked important questions about What if the math is wrong? What if they got all the facts wrong? What if it's just a facially invalid opinion? Somebody from the court ought to do a review where they can at least assess the reliability, admissibility, really key questions, fundamental questions about evidentiary value. Weight is not really the issue. It's really about admissibility and integrity. And I think had that happened here, had there been a provision in Johnstone allowing for, and even frankly requiring judicial scrutiny of some sort, that could have taken place over the 14-day period and we wouldn't be here.
But you're talking about going forward. Obviously, your clients have notice now.
Have no what?
They have notice now. It's been...
Correct, yes. And to the mootness question, I certainly concede that the 14 days have passed. But this is obviously a case where there will be repetition, yet evading review. I think to Justice Seifer's question, there are probably lots of victims and people on the registries who didn't get 14 days notice, but just didn't know that they didn't get 14 days notice or didn't know they had a right to 14 days notice. I'm not sure. But we know that lots of Johnstone releases have happened, and to the extent they happened with that immediacy, as Mr. Chapman's lawyer suggests is required, then I think it's fair to infer that there's lots of violations of that regulatory mandate of 14-day notification that are happening, and because victims are so invisible in this process, we don't even know. And that, too, is part of the problem. You know, it's also not unreasonable to suggest that this case be considered notwithstanding mootness because it does raise systemic questions, and as this court has held in many cases, Bradford versus Knights and others, when there is a systemic problem, 211.3 is the correct vehicle even when the party has no standing or even when the case is moot. This court is not only permitted, but frankly, I think duty-bound to address the systemic injustices because these are non-parties with little access to information about what's going on. They are voiceless. They are not routinely involved in participating, and that's fine. We're not seeking standing as a party to act like a private attorney general or participate in any way in interfering with the rights of the accused or the rights of persons civilly committed.
Well, you say that, but am I correct that the consequence of what you're asking for is that if someone is deemed sexually non-dangerous, that the Commonwealth, for whatever reason, having received the QE reports, decides not to proceed, that you say that person should be held for 14 days to give the victims appropriate notice? The
14-day notice is mandatory.
Okay, try my question. Is it your view that that person should be held for 14 days even after determination is made that that person is not sexually dangerous in order to provide notice to the victims?
Yes, because that's currently the law, but also because there should be some form of judicial scrutiny. And that 14-day period, though it's important to victims to get that notice for a host of reasons that should matter, it also would give the court, the Superior Court, an opportunity to review the QE reports because there should be no immediate release of an offender without someone in the government, a judge in particular, taking a look at those reports and saying, these are in order, they are reliable, they are admissible, and they do merit the release of this person. There's no way two qualified examiners should have total control over the decision-making process, and it just so happens that also violates the 14-day notification rule.
All right,
thank you.
Mr. Schneiderman.
Good morning.
Good morning. May it please the court. I am Joseph Schneiderman. I represent Wayne Chapman. Your Honors, the victims deserve our sympathy, and the Commonwealth has an obligation to inform them of any prospect of Mr. Chapman's release. However, the single justice correctly concluded that the victims have not suffered the irremediable deprivation of a substantial right because in the end, the victims do not have the right to 14 days notice of Mr. Chapman's release, and they have not built a record to show that this is indeed a systemic issue relating to the administration of justice to overcome prudential concerns about standing under 211.3. Regarding a substantial right, The victims are not listed in Chapter 123A. The victims are not listed in Chapter 258B. The victims do not have statutory standing as parties, and that is effectively what they are seeking to do, which is to appear and advocate as parties in the sexually dangerous persons proceeding to assert that they have a right to 14 days' notice. They do not have that ability to appear as parties under either statute. Very briefly, while I'm on that point, I want to address something my sister said. My sister asserted that Chapter 6, Section 172 is the regulatory source of 803 CMR. That's correct. Chapter 258B, Section 3, though, is also the regulatory source of 803 CMR. So, and because there is this court in Hagan has held that the provisions of Chapter 258B are not judicially enforceable ones. They are ones that the Commonwealth asserts in the victim's name, but they are public ones, much like how a sexually dangerous persons proceeding or a criminal proceeding is brought in the name of the Commonwealth, in the name of the public. So the victims cannot advance their claims that way, and indeed, as this court recognized in Hagan, Chapter 258B is not intended to alter the longstanding rule that one person does not have a judicially cognizable interest in the deprivation of liberty of another. So to the extent the victims are seeking to demonstrate that they have standing, there has to be a statutory source for that, or there otherwise has to be a classical injury or invasion of their rights, and neither provision, either of the statute or otherwise, provides them with that opportunity. Turning a bit to the merits, Chapter 258B, Section 3T, which is the source of these regulations, reads advance. It's up to the Department of Correction to determine what advance notice is required and how much advance notice is required. Indeed, as Justice Seifer noted a moment ago, the DOC has anticipated this sort of a scenario of a short release or a release with very little notice. And a release in a sexually dangerous persons proceeding is inherently court-ordered. Chapter 123A, Section 9 says, the court shall discharge if a person is no longer found to be sexually dangerous. So that is how a release is going to occur. To my sister's suggestion that there should be 14 days, as is long recognized, to any time spent in prison or in confinement, one can never get back. One could never get back 14 days, and as a practical matter, there is some delay built into a Johnstone release. It's my understanding that when the QE reports are filed, with the court, because one simply can't be released on the spot from Bridgewater to the street, there is time to find a placement for someone to be released, and at that point, once they have that placement, the petitioner moves for judgment in the Superior Court, and once judgment enters, they are then entitled to release.
Pragmatically, the court does not necessarily monitor the filing of the QE reports. I assume that the court awaits a motion from the defendant saying, I wish to be released.
That's absolutely correct, Mr. Chief Justice, and that's what happened in the record of this case, which is the QE reports were filed on May 21st, and there was no motion for the entry of judgment.
So, in theory, the Commonwealth, of course, would receive prompt notice of that motion, and the Commonwealth could inform DOC, who could then inform the victims.
That's absolutely correct, Your Honor. The Commonwealth is best suited to stand in the shoes of this, and indeed, the record bears out that the Commonwealth more than fulfilled their obligation. At Supplemental Appendix 72 through 73, the Department of Correction appended the affidavit of Allison Numella, who said on May 21st, which was basically the same day that they received this notice, the record reflects that the email was sent on May 20th, which was a Sunday. On May 21st, Allison Numella contacted 3 of the 4 victims and reached 3 of the 4 victims, and the 4th victim returned a phone call to her colleague, Richard Ortwine. So the Commonwealth has done all it's needed to do to notify the petitioners of Mr. Chapman's potential release, and indeed, by the time the single justice ruled on their petition, his release had not in fact occurred. So in the end, the rights the victims seek to assert are lodged in the Commonwealth, and it's up to the Commonwealth's objective decision makers on how to implement those rights. And the Department of Correction has made a decision about what advance notice is required and how much advance notice is required, and that's reflected in the regulations. And each regulation, much like each provision of a statute, has to have its own freestanding meaning. I would just note that the victims have made much about this court's extraordinary power under 211.3. The victims, though, have not built a record to establish that, and that is rule number 1 of single justice practice, which is it is the petitioner's burden to establish an adequate record of a systemic claim of error, and if they have not done so, this court does not infer one. In Brantley, there was ongoing litigation back and forth in the single justice session about Hamden's protocols, and because the violator of rights there was the Hamden Probate and Family Court, this court opted to relax standing. Unless the court has further questions, I thank you kindly for your time.
All right, thank you.
Thank you.
And Ms. Murray, we begin and end with you.
Mr. Chief Justice, as anyone who's ever met me knows, having the last word is something that I always value. With respect to the timing of notification to the victims and to petitioners under the regulations and the statute, the Commonwealth absolutely agrees with Single Justice Kafka, who said they are entitled to scrupulous focus and attention and compliance with the regulations. The regulations obviously contain 2 different provisions as to when 14-day notification is feasible and when it isn't. Court orders, SDP discharges are by court order. So the qualified examiner opinions, if they say not sexually dangerous, that is not what enters the discharge, it's a court order. I did want to address a couple of points. The qualified examiner reports are filed directly with the court under the present practice through a discovery and scheduling order that dictates the timing of them. They were due on May 21st, they were filed on May 21st. I became aware of them on the night of the 20th because I was working on a Sunday night and I saw my email, and I immediately alerted our victim services folks so that they would have it first thing Monday morning when the reports would be filed with the court. So that's how that transpired.
And when there's a motion?
Excuse me?
When there's a motion brought by somebody?
Typically it is, although sometimes the discharge order enters on the same day that they are filed. No, with a motion, but the motion is 3 sentences, if even.
It can happen without a motion. Nothing happens without a motion.
It happens with a court order. So typically
which
a motion. Typically a motion is filed.
Okay.
But the court enters the order.
Right.
Yes, and that's how the practice typically works. Whether it's ever happened without a motion, of course, in the scheme of every case that's ever come before the court, not typically in Section 9s, but the initial commitment cases, I couldn't speak to the record in every one of those cases, but a court order is required. I did want to address one point that Ms. Murphy raised, if I may, which is recommending that there be some judicial scrutiny. Well, in order for the court, the judge who's given these reports, to understand whether there's especially factual error or omissions, like in the case of Cowan, where one of the qualified examiners said not SDP, and admitted that he hadn't even read some of the police reports or the letters from the offender to the victims from prison, which were highly sexual and graphic, you would need to have all of that information brought forward to the court. And that would result in essentially at least a mini trial, which would then result in litigation for either side to appeal if they're unhappy with the outcome of that. The most effective and efficient way to test the means and sufficiency of those opinions when the Commonwealth has other expert opinion is through a trial on the merits. That's the most efficient and effective way, because the judge, without hearing all of this other material, is not going to be in that position to assess the integrity of the report, the reliability of it.
A year or 2 later?
No, because the trial has a date. The trial has a date. The Commonwealth is not going to be allowed to endlessly postpone trials. The Commonwealth has to be ready for trial on a certain date.
What's the average of trial length when there's a finding by a QE that someone is sexually dangerous and then it goes to trial?
Our trials are typically 5 days.
No, I'm not talking about the length of the trial.
I didn't understand your question.
Not the length of the trial. The time to go to trial.
Oh, the qualified examiner reports are filed by court order 9 weeks before the trial, and then we go to trial 9 weeks later. This is a very...
I remember seeing you in these trials.
Right.
I get it. But what I'm asking you is, what's the average length to get to trial?
Oh, from the time of the filing of the petition,
Right.
it's about 2.5 years. But an individual can move to advance that and make a showing. This court talked about that in Pentlarge, as single Justice Cowan did, make a showing that he should be advanced above other people. And that typically happens when the CAB has a split or majority opinion that the person is not sexually dangerous. So that's one of the bases. But it's about 2.5 years.
And that's for Section 12 or Section 9?
Section 9.
And for
Section 12, they vary in length, but there's a statutory deadline for those.
I know
And as
there's
we
a
discussed
statutory-
earlier.
Remember, you've got 5 former Superior Court judges. So
Right, absolutely.
But
But
what is
they
the
can-
length of time from the QE report being filed until trial on average in a Section 9 proceeding? I'm sorry, Section 12 proceeding.
From the, that I don't have the data on, but that, because there is a statutory limit, is well within the control of the Superior Court, as we talked about earlier, to force the parties to go forward to trial within the 60 days, or the statute does permit on good cause shown that can be delayed. And if any party thinks that it's not good cause shown, then of course they have appellate rights, which is exactly what they can exercise.
Okay, thank you.
Thank you.